The Attorney General, Godfred Yeboah-Dame, says he will not counsel the president to endorse a law that infringes people's rights. He spoke in an interview with Morning Show host Kojo Jansen hours before the passage of the Proper Sexual Rights and Family Values Bill 2024. He's also raising concerns about the rising tide of judgment debt lawsuit that has flooded his office in this exclusive interview.
Trillion Ghana cedis. I'm not sure I've even heard that number said out loud before, but the president certainly said it during the State of the Nation address. He says that the Attorney General, through his actions of defending the state against judgment debt claims, has saved Ghana 10 trillion Ghana cedis. That's some 1 trillion United States dollars. And of course, there was a reaction to this. But then the president said the evidence is all there. Well, that's why we are here, to find out from the Attorney General himself what evidence there is to back a saving of 10 trillion Ghana cedis. Thanks for having us. So let's jump right into it.
Right.
Sikanu.
Well, I think they're all there. They're all made out in claims made by various people, litigants, against the government of Ghana. And indeed, it's very important to note that these sums were saved in furtherance of our constitutional rule and Article 88 to the Constitution. If you remember, when I assumed office, I made a commitment to a nation that the same zeal with which private legal practitioners contest claims against their clients is what I also bring to the office. And so, to go straight to the point, 10 trillion Ghana cedis.
Yeah.
Now, you see this order for Ghana Ghc10 issued in the High Court of Justice, Commercial Division, Accra. And what is the sum here? And if you can just read the order.
Right. I'm looking at 10, oh my goodness, so many commas.
Yes.
10 trillion, 331 billion,
Yes.
841 million,
Yes.
859,411 Ghana cedis, and 20 pesos. Let's not forget the pesos.
Sure.
So what case is this?
So that is African Automobile Limited against Ministry of Employment, Manpower Development, and the Attorney General.
Someone
and of course,
sued
by the description of the ministry, you would note that clearly it's a ministry of oath, because under the government of President Akufo-Addo, we do not have Ministry of Manpower, Employment, Ministry of Employment and Manpower Development. You have Ministry of Employment. So these are judgment debts that were claimed against the government of Ghana way back, of course. By dint of my role as Attorney General, I've had to defend them. So on the 26th day of April 2021, an order for Ghana Ghc10, implying that an amount in the sum of 10 trillion 331 billion 841 million Ghana cedis has been ordered to be paid by the government of Ghana. And you see the amounts here stated here, that the banks against which the sums were supposed to be paid from. The accounts are accounts being held by the Bank of Ghana, Head Office, Ghana Commercial Bank, Head Office, and Consolidated Bank, Ghana Limited. So right after this order was served on us, we were quite alarmed, and I assembled the whole team here. I gave them further directions on it. And this was, as I said, 26 April 2021. So on 31st May 2021, the High Court set aside the ordered that the sum be not paid. Now, so you see, this is the judgment of the High Court.
Right.
The ruling of the High Court, 31st May 2021. And the concluding parts are most instructive. It says, it is therefore ordered that the Ghana Ghc proceedings regarding the applicant's indebtedness should, so in this one, the subsequently pursuant to the challenge that was made by the Attorney General, revised the figure downwards to 3 trillion Ghana cedis. Now, after the revision, then an action was filed by us to set aside the entire judgment on the basis of fraud, that the government of Ghana was not owing any sum at all. So this is it. So indeed, it is correct to say that 10 trillion Ghana cedis was claimed against the government of Ghana, and 10 trillion Ghana cedis has been avoided. And that is just one suit.
Right.
Now you go to many other suits, if I may.
If we can finish with this particular one, sure. Because I mean, I've never heard of such a thing.
Yes, it is.
So walk us through as much as you can about this case.
Yes.
When was this judgment awarded against the government of Ghana?
Right.
And what are the facts?
Right. So the judgment itself was awarded in 2011, under the SFA NDC administration 2011. And it went all the way to Court of Appeal, was affirmed again by the Court of Appeal. And then the processes to set aside judgment commenced in our time, in our administration. I mean,
so this all happened in Ghanaian courts?
Yes, Ghanaian courts.
10 trillion was awarded against a party,
yes. And the law firm,
the government of
the
Ghana.
law firm is reputable as this legal. If you are familiar with law practice in Ghana, it's a law firm that I think is headed by Professor Abuchi. So the lawyers are there to verify. So all these claims are there.
What were they claiming 10 trillion for?
Well, for some supply of vehicles and equipment to the government of Ghana way back in the 1990s. And of course, so claims arising out of breach of contract. And that is actually a reason why I have been compelled to get Parliament to enact a law which seeks to amend the Contract Act by which the payment of compound interest is prohibited against the government of Ghana. Because before I assumed the reins as Attorney General, indeed, I observed a trend for various public officers to the process of compound interest actually inflict unnecessary judgment debts against the government of Ghana. So remember the case of NDK against the Attorney General,
yes,
which I again applied to the Supreme Court for another stating that the sum of 79 million Ghana cedis paid by the government of Ghana was sufficient and therefore should be declared as full and final payment. And the government was relieved from the obligation of paying the sum of 1.27 billion Ghana cedis. If you remember, was reported widely by your station, Daily Graphic and all that. The sum in question was a paltry 268,000 Ghana cedis, 268,000 Ghana cedis.
That was the original amount awarded,
sum,
right?
In 2009, was 268,000 Ghana cedis. But by the process of computation of compound interest, the sum increased to 1.3 billion Ghana cedis. And after an amount of 79 million Ghana cedis had been paid by the government of Ghana, NDK was still pursuing government of Ghana for payment of 1.27 billion Ghana cedis. And I made the application to the Supreme Court that on grounds of equity and what have you, the sum paid by the government of Ghana should be awarded as, or should be held by the court as having fully satisfied the judgment debt. And that's what actually motivated me to lay before Parliament the Contract Amendment Act. And Parliament, thankfully, passed the law July last year. And I believe the President has assented to it. So now, no public officer is permitted to engage in a transaction in which the interest arising from a breach of the government's obligation will be calculated on the basis of compound interest. It will just be simple interest. Because indeed, when I was conducting the NDK case, I realized that if there had been a computation of interest rate at simple interest, the amount paid would have just been a paltry sum. And the Supreme Court actually held, pursuant to my application, that the sum owed by government of Ghana, or that sum outstanding, was only 14,000 Ghana cedis.
Wow.
Compare 14,000 Ghana cedis to 1.27 billion Ghana cedis.
So in this
case, 10 trillion Ghana cedis.
What was the original amount awarded that started gathering the compound interest?
The original amount was far, far lower. The original amount was about 971,000 Ghana cedis.
Less than a million Ghana cedis?
Yes, from 1997 to 1999. And afterwards, and I think that so the process of judgment debt for me had become a conduit for milking the state. Had become a conduit for necessarily inflicting financial hardships on the state. And some people had more or less permitted it to be an enterprise. And we saw various judgments of the Supreme Court between 2012 and 2016 reflecting such a tendency. And so I'm not surprised at all.
Well, I mean...
but that's just one case, 10 trillion.
And
you
in fact,
walk through the other cases. That's why I said that
to wrap on this case, if you don't mind, what is the current state of things? I know you've got the Ghana Ghc10 order quashed.
Yes.
But is the matter concluded? Is there room for appeal? Could we still end up having to pay?
Yes. So we've set aside, we've applied for the judgment to set aside on the basis of fraud at the High Court, and pending that, no action or step can be taken to execute it. And I believe that clearly the High Court will uphold the action that we have commenced. Because there's no basis for
yet done.
Well, they recently, the people affected, those who are claiming the 10 trillion, recently only filed their defense.
Right.
So let's see.
I'm just asking these
Yes.
to be sure that we've actually saved this money already, or that we will save it at the end of this process.
On account of the principles established in the NDK case, clearly, this sum will not be paid. How justifiable is it that the amount which by 1999 was 979,000 Ghana cedis now should balloon to 10 trillion and people should be paid? And I think previously, people were encouraged, motivated to engage in such acts because you find public officers, whether from Ministry of Finance or the Office of the Treasurer, even sitting down to negotiate with them and all that, encouraging such negotiations. In my time, with all respect, such practice will never prevail.
Although government of Ghana, between 2017 and 2021, have still paid out some $300-odd million worth of judgment debts.
Yeah, of course. Clearly, judgment debts arising as a result of various situations cannot be avoided. And indeed, I was earlier on explaining to you that if a policeman perhaps engages in some act of brutality against a citizen, the person will go to court and sue the treasurer. In such an instance, there are many instances where I find on my table courts awarding sums of over 400,000 Ghana cedis and what have you, in cases that you cannot use your legal ingenuity to orchestrate a defeat of the applicant. And I think that indeed, from the perspective of law and fairness, if a person has suffered genuine, has suffered genuinely as a result of officers of states engaging in negligence and on other tortious activities, it will be inequitable for you to say that such a person should not be paid. So yes, there may be instances where a person clearly will be owed a claim, and that should be verified. But I'm talking about situations where dubious, unwarranted claims, as this, have gone through the courts and prevailed. And those are actually the huge cases that bring a burden on the taxpayer. Are
there many more such cases where compound interest has turned the number into something astronomical?
Yes. I told you about how the Supreme Court quashed the payment of compound interest in the NDK case. And in the NDK case, it was actually remarkable. When I finished concluding the matter, I received a call from Marita Brew congratulating me. It's a matter of record. She had called me a number of times, sent messages, congratulating me on it. And then I called her back and she said, yes, because the matter that had been of concern to them, they were struggling or they were finding it difficult to deal with it. And therefore, she found it quite remarkable that I had been able to put it to conclusion and all that. These are matters of record, messages and all. So then we have this one, another African automobile matter. There's an action that was pursued by Sorry and Co. Sorry at Law.
Yes.
It's a matters of record. Sorry at Law. You know who Sorry at Law.
Yes, Albert Sorry. And his law firm. And you can verify. You see the entry of judgment here. What is it for? Oh my goodness, these big numbers.
582 billion.
582 billion
Ghana cedis.
1,748,751 cedis. No pesos this time.
Right.
What's this about?
So again, a claim for some breach of contract by the government of Ghana, and this is what they allege was owed by the government of Ghana. Ultimately, when an application was made to the High Court in 2020, 10 February 2020, the court suspended the execution of the judgment and actually held that we could issue a rate to set aside the entire action on the basis of fraud. So you say applications are accordingly granted and the execution aforementioned is hereby suspended pending the hearing of the matter. And so not a dime has
So
been
when
paid.
you say that these actions are being set aside on the basis of fraud,
yes,
what you're actually saying is that some people in government before you colluded to have these judgment debts awarded when there was really no case for such payments to be made.
Well, I think that it is actually as a result of one, vigilance, lack of vigilance on the part of public officers, or sheer complicity in the process of ensuring that the state is ripped off with hard-earned purse. And I say so for the reasons that were given by the Court of Appeal and its judgment in the Worumi matter. You find the criminal matter instituted against Alfred Worumi. The Court of Appeal giving a judgment on the submission of no case that had been made by Alfred Worumi. No, so the Alfred Worumi had been prosecuted, and the High Court had eventually acquitted Alfred Worumi. And the state purported to appeal against the acquittal of Alfred Worumi. And the state clearly heard that the Court of Appeal heard that the state had no case at all, because the state itself had, through its processes, orchestrated for Alfred Worumi to profit from the judgment debt and turn around to prosecute only him, leaving out the public officers in question. And the public officers were officers or officers at Tangier, as well as the Minister of Justice. So, if I may quote from the judgment to the Court of Appeal in 2016, 10th March 2016. You see, this is one. And this is actually it's a panel of three. Each of them gave an opinion. I'm just quoting from only the opinion of Justice L.L. Mensah. The others were even worse. Justice L.L. Mensah said, indeed, in the instant case, the trial judge should have terminated the trial and upheld the submission of no case, because the evidence of virtually all the prosecution witnesses, including PW1, whose name is there, an officer of the Ministry of Finance, through PW.
If its name is there, you can say it
through
for
PW9. us. No, but I don't want to be misled. She's actually a lawyer.
Right.
But in terms of those who orchestrated, actually some other officers.
Right.
And anyway, with the evidence of the PW3, PW7, PW8, and PW9. When I say PW, it's prosecution witnesses.
Yeah.
That I've highlighted, all go to bolster the defense of the respondent. So imagine a situation where the state puts up a prosecution and all their witnesses were supporting the case of the accused person. Clearly meant to fail. Then it says here, at page 8, it says, once the whole armada of the government of Ghana, legal, financial, administrative, technical, ministerial, or consultancy machinery combined together to act on the purported misorientation of the respondent and found the claim to be impeccable, the respondent cannot be convicted of a transaction which the state had blessed all the way. And indeed, you will see that the officers of state who actually blessed Woyomi's transaction were named specifically in this judgment. At page 7, it says that the then Honorable Atenjira and her deputy, Honorable Bachondro, who between them wrote 4 letters in support of the respondent's claim.
So that would be Betty Mould Idrisu at the time.
Precisely. Did not only use their ordinary care and judgment, but they fell on their legal professional expertise to assess the claims of the respondent. And they did this not in isolation, but with the advice of 2 other legally professional brains in the persons of Paul Asmenu, head of legal for the Ministry of Finance, and Samuel Nekwetete, Chief State Attorney.
So you're suggesting there's a pattern that
yes,
runs through these cases? The
question that ought to be asked is that, how can a group of people in government, through this judgment, as has been affirmed in this judgment, actually machinate for a person who is not a public officer to have access to the state's hard-earned money, at that time the equivalent of about 25 million euros. And then subsequently, if it emerges that the whole transaction was fraught with fraud and irregularity, they purport then to prosecute the third party, who is not a public officer, and left themselves out, and left the public officers out. Carefully did so. Clearly. I think that yes.
If I may, I mean, with respect, you are in office today, and you are showing us evidence of cases where you have had judgments overturned and saved money, as you describe it. But you see, in the examples given, it was made possible by people in offices such as yours, right? Who's to say that a year or 2 after you leave office, we're not going to find out that there are perhaps a couple of $100 million that were handed out to people in similar circumstances. Unless you, as the goalkeeper, letting the goals in.
Well, there has not been any instance of a claim against the state passing through this office which was not contested. Unless in cases of, say, a police officer, as I said, a police officer beating a civilian, or some clear case of, even, say, my driver, officer of the office of Attenjura, using an office vehicle, runs down a person. Are you going to say because you're Attenjura, you're not going to ask or permit the person to be punished and all that? But there has not been any instance of the state using its armada of government machinery, as was held in this Oyome case, facilitating the payment of any judgment debt. I can say with all the confidence I can marshal.
Now, you have several cases here.
And indeed, it is also worthy to note that when the MPP left office in 2009, January 2009, NDC made similar noises. The same officers here who have been mentioned, the Attorney General and the Deputy and all that, shouted on various platforms that they're going to prosecute the MPP administration for corruption. I was the one who conducted the first criminal trial when the MPP was in opposition. Ekwesio Seiji tried for allegedly stealing rice over 1.5 billion Ghana cedis and all. At the end of the day, the prosecution fell flat after the state had called 70 witnesses. No case at all could be sustained. And the same story could be told of all other cases mounted against officers of the Eswa Kufuor administration. You talk about Asamoah Barton, the prosecution of Asamoah Barton and his wife, prosecution of Akoto, the late Akoto say, and all. Talk about even the Ghana Ghc10 prosecution, which they made so much noise about. Not a shred of evidence was laid. So I'm used to NDC making all these noises. Now, yes. The opposition, they're crying foul over a lot of things that clearly do not amount to any criminality whatsoever.
There are some
they're making the noise. They're making they're making the noise. When they can't, they'll prosecute. Similar noises were made by their people. I think that the nation must really be able to distinguish between light and day. To distinguish between night and day. I mean, I think when it comes to good governance, the record of the NDC cannot match up to any standard at all.
There are some who might say that your administration is pretty much doing the same thing with cases like Opuni and Dr. Ato Forson, you know, where lots of noise has been made.
Right.
Now these people are being taken through court, and some of the cases, in one case, the thing has dragged endlessly, doesn't seem to be any end in sight. Looks like there was a lot of noise at the beginning, but the result is just not showing itself.
Yeah, but the case,
is it not the same thing?
No, but the case is staying too long in court. That does not amount to saying that the persons have been acquitted or that the prosecution was frivolous. The frivolity or the legitimacy of prosecution can be established only upon the conclusion of the matter. And indeed, I'm very confident of a conviction in most of the cases we're talking about. So far, all the major cases that they have been conclusion to, we've had success in them. Even more contentious or more complex matters, treasons, murder, and what have you. What about simple cases as fraud and all. And that is why they are resorting to all these machinations of appealing and hurting the judicial process. I have the benefit of experience. And again, I will follow my experience. When I was in private practice, I never resorted to all of these gymnastics that have been resorted to by lawyers. I conducted a CJ trial within about 10 months. The trial court acquitted him on 6 out of 8 counts at the submission of no case stage. I felt aggrieved. I appealed to the Court of Appeal. Court of Appeal presided over by Justice Apau and considered by other judges, Senor Jamafe and I think Mariam Owusu. Mariam Owusu was actually the president of the panel, and then considered by Justice Apau and Senor Jamafe as the panel members. Acquitted him on the other 2 within a period of about 6 months, 16 months. The entire trial had terminated. And so if you are a practitioner, you believe in the strength of your case, there's no way be resorting to all these unnecessary gymnastics.
You have quite a pile of cases here.
Yes. And I'll quickly run through them for you.
Well, without you having to run through them.
No, to show that indeed the savings that the president announced were actually an underestimation. The president grossly underestimated it. And it was actually my doing, because every minister has the responsibility of bringing to the president's attention the work that the minister has done. And in presenting my report, I deliberately understated the account, just not to raise unnecessary eyebrows and to be unnecessary sensational. But if you go through, 10 trillion is just arising in a single case. If you go through, the savings are actually over 14 billion. 14 trillion. Yes, I can refer to this matter, China Jinlin, which the Supreme Court set aside only last year. The judgment that year, if you look at the figure here, originally, and then all the time, Ghana Ghc10, it was in the High Court of Justice, I think in Kumasi or so. The transport minister actually came here and made a lot of noise about it because it affected his account and all. And we took it up and compared to situations where ministers and the also administration would team up and orchestrate and facilitate judgment debts. It is this amount of 352 million. So that the figures are even dizzy. You can't even 352 million Ghana cedis. 352,662,144.41 pesos. And then an amount of almost $1 billion, $988 million, 294,313. That is it. So almost $1 billion plus 325 million Ghana cedis. So the Supreme Court again in 2022, after 2023, in the conclusion, says the application before the court that we have quashed the ruling given was expressly to set aside the Ghana Ghc10 order and without prejudice making the controversial setting aside order. And they granted the order quashing all these proceedings. And interestingly, in this judgment, the court actually held that, as we contended, that the persons who had mounted the action even had no capacity whatsoever. And the identities could not be made out. A person who was a foreigner holding a power of attorney, which had not been properly notarized, and who had even died later on in the course of the trial, and therefore could not have given another power of attorney to another person to pursue the trial. Was allegedly pursuing this matter. And the court said, no, our contention was right. And therefore, if they want to mount the claim, they must come and properly establish their authority. To date, they have not come forward.
For all these cases, I have only one question.
And then you talk about the numerous international arbitration cases, which the state also has enjoyed remarkable success. And I think that it's a matter of record. For the past 2 years, the rest of Ghana has actually been chasing me to come and give a lecture to their LLM people on international arbitration. I have not had the time to do so. I think this is our because indeed they are quite impressed by the remarkable rate of success and just want us to enlighten them on what Ghana is doing right. Now, $300 million was claimed by a company, Cassius Mining. That was refused by the Permanent Court of Arbitration, pursuant to objections that we raised. I have a copy of the judgment here, and if you just would permit me, this is it, the 91-page award of the arbitral tribunal. Now you look at
300 million US dollars.
Yes. So page 7 says, okay, this is actually even under one for 60 million USD. The 300 million also there, and eventually was suspended. And today, I think the people, after the denial of the original claim, pursued another international arbitration, and we raised various objections and all. I think the ruling should have come in either today or, if not today, maybe tomorrow. And this one that I have in my hand is for at least 60 million USD. It says, finally, look at page 7. The claimant seeks an order awarding Everyway, the Beijing Everyway company, the traffic system, damages which it has incurred as a result of the aforementioned breaches of a treaty, amounting to an estimate not lower than $55 million. At the time of this claim, the interest component had shot the amount out to over $60 million. The conclusion, which you see here, after we had raised all the objections to the inapplicability of the treaty and whatever, the court said, for the reasons...
Which year was this?
Oh, this was just last year.
Right.
It's just last year, or last 2 years. Let me see. I mean, most of these cases are from 2021 when I assumed the office. Right. So it's January 2023, last year. It says, for the reasons set out above, the Tribunal A opposed the respondent's objections to the Tribunal's jurisdiction and finds that it has no jurisdiction to decide the claimant's claim in this arbitration. And they invite the parties to directly confer on the issue of cost. We actually decided not to pursue any cost at all. The most important thing was for us to win and to throw the appeal out, which we did.
All right. Now, for all of these cases, I really have only one question.
Right.
Are they all concluded, or are there opportunities for appeals? Could any of these rulings be overturned, or have you actually saved us these amounts?
Yeah, most of them have been concluded, and I'm very sure that the ones that are not concluded are actually the ones that we have issued writs to set aside the original judgment on the basis of fraud. And indeed, the court has, in consequence of our writ, issued orders suspending the execution of the judgment or setting aside the order for Ghana Ghc10, implying that the payment cannot be made at all. You know, and I'm very confident that on the basis of all the reasons I've advanced, the claims no doubt will be defeated.
Right.
Yeah, in one of them, the 10 trillion one, our view is that the amount owed is only about 56,000 Ghana cedis or so. If at all, that's what we paid.
Well, we will certainly go through all of these documents with our cameras for the benefit of our audience.
And the lawyers are there to verify. I've showed you mentioned law firms who are pursuing them and all that. So,
before we wrap up, a couple of updates, if you may. Another area in which you've been commended is the number of prosecutions you have managed to put under your belt in the area of Galamsey. The criticism, however, is that we are not seeing the kingpins, the people who are funding these, you know, small fry, if you will, to go into the pits and dig. Why not? Why haven't we seen any kingpins locked up?
I think you are. Hitherto, the noise was that Galamsey activities are being funded by Chinese citizens. Is that not correct?
Yes, that has
and
been
the major kingpin was who? Mentioned as who?
You mean Aisha Huang, the recently...
Precisely. And where is Aisha Huang now?
But that's just one person.
No, hold on. I'm saying that you are seeing the kingpins being thrown into jail. Aisha Huang has been convicted after coming to the country. There was the case that we mounted against Aisha was actually one of the most difficult ones. There was no direct evidence of Aisha Huang on a mining site. Nonetheless, everybody knew Aisha Huang was engaged in Galamsey activities. It tells you that she was actually operating behind the scenes, funding people. We had to actually dig into her arsenal, chase up evidence relating to writs that had been issued against her by various persons who had alleged that she had encroached on her land, on their lands and all that. And then brought up all these witnesses from Bepo Tintin and Bogoso and other places and all to mount the prosecution. It was actually an overwhelming circumstantial evidence. You know the rule in circumstantial evidence where it irresistibly points in one direction and the necessary inference can be made. And that is why Aisha Huang was convicted. Before then, there had been the jailing of various Chinese nationals by the Takwa Circuit Court. We had 2 Chinese nationals thrown in for 25 years. Well, the law, current legal regime, requires that if a foreigner is engaged in such activities, the minimum penalty is, or punishment is 20 years. And for a Ghanaian, 15 years minimum. And then there was also a conviction by a Takwa Circuit Court of 2 Chinese nationals and some Ghanaians, if you remember, where the punishment existing under the SY regime was imposed, implying that they could be fined and all. And they were fined and allowed to go. And I actually had to instruct for the filing of an application for certiorari in the Secondary High Court for it to be quashed. So fortunately, National Security, National Security rounded them up, fortunately, when the application was filed, and then the judgment was passed accordingly, and now they're all in jail.
Now, because you mentioned Aisha